Hi, welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand 4 fundamental questions about property. Today, we're talking about the third question, which is using property. In other videos, we've talked about what a nuisance is. We've talked about pig farms and odors and bright lights. We've also talked about how sometimes, unfortunately, nuisance law has treated people as nuisances. But in that broad frame of nuisance topics, we talked about the way that nuisance law has been handled. And specifically, it is through a case-by-case process of litigation that can be costly and expensive. And if a nuisance is found, the person receives a remedy, but only after undergoing this very costly process. So from a practical standpoint, think about how this actually works. So a loud and smelly dog kennel next door can be a nuisance. If you're a neighbor who objects and you only have nuisance law, the only thing you can do is hire a lawyer, go to court, have your neighbor hire a lawyer. You both have to assemble facts and videos, affidavits and photographs. You both lose time, you both lose sleep. And by the way, you're still living next door to each other. Now imagine that you live in New York City, or really any city for that matter, at the dawn of the 20th century. In an era of rapid development, disputes among neighbors came up again and again. People soon realized that the courts are just not an effective or efficient way of handling disputes over competing land uses. They realized there has to be a better way. And as that turns out, that better way is zoning or public land use regulation. The first citywide zoning code was developed in New York City in 1916, though Los Angeles and other cities had experimented with more limited forms of zoning before that. The New York City Code served as a model for the Standard State Zoning Enabling Act, which was published in final form in 1926. And by the way, it's been adopted in all the states. State statutes based on that model law dictate how local governments can set up their zoning regimes. In other videos, we will talk about what zoning is, how it works, and what Supreme Court decisions justify it. But for now, it's important to understand how the constraints of nuisance law gave rise to zoning law. There are important differences between nuisance and zoning law. Nuisance influences land use from the bottom up, while zoning governs land use from the top down. Nuisance influences land on a case-by-case or property-by-property basis. Every nuisance case will involve the weighing of facts and evidence so that no broader policy is created. Zoning, however, establishes rules that apply to whole neighborhoods or apply to the city as a whole. It sets out the rules in advance. And enforcement is done through public officials, usually zoning staff, paid for by taxpayers, not by individual neighbors. Today, nuisance law has not gone away. It still exists, and it coexists with zoning, which is the public way to regulate land use. So with that brief history of the evolution, I will leave it there. I hope to hear from you through Twitter or through my website where you can sign up to my mailing list, and I will see you next time.